Hi, this is Jim Cunningham. We're going to talk about estate planning for college students and high school graduates. So as these kids of yours or grandkids of yours turn 18, it's a whole new world, right? So you go from kid to adult, 17 and 365 days and poof, you're an adult. So we're going to cover here a lot of things that are very, very important. Even though you're for boys or men, I guess, your prefrontal cortex is not fully grown and developed until you're 25, you're still an adult at 18, or kind of an adult. And you'll see there's some things you have to wait until 21 to do. But it's very important to understand from the parent's standpoint, or the guardian or a loved one, or maybe even a step parent or a grandparent who really cares about this child who's becoming an adult. You lose access to medical records and decision making. So this is probably the biggest shock. And I have 3 adult children of my own. And kids are once they become adults, they have a mind of their own, and they do things that you may not always agree with. They may do things that might harm them. And frankly, there's not a lot that parents can do about it once they turn 18 because they're adults, right? They have the ability to make good decisions as well as poor decisions. We're going to cover the legal consequences, really, that I think every family should consider with college-age kids. And I gear this, even if a child or grandchild's not going to college, these are college age. So these are typically the 18 to 25-year-olds, where they're kind of transitioning out of being a child into the adult world. And a lot of times they can get themselves into financial trouble. They can get themselves into legal trouble. And I'm going to go over some things that can help them if they do get into trouble. So we're going to cover a uniform statutory form durable power of attorney, as well as advanced healthcare directive, the last will and testament. And actually, we'll have some links in here. And these, if you're watching this on YouTube, we're recording this live and it's on YouTube. But these links will be put into the YouTube on the page where the video appears, so you can click those and get some free resources. These are available. These are California resources. Many states have similar documents, but these are things that are free to the public that the legislature has kind of helped people along. Now, this is not a substitute for comprehensive estate planning. It's important to note. It's also not a substitute for legal advice. So if you're listening to this, please don't take this as legal advice. When I say you, there's no attorney-client relationship, and this is really for information purposes only. The bottom line is, don't watch this video and go out and do a bunch of stuff. I would say, other than completing the statutory form powers of attorney and wills, and there's instructions that go with those, and that's something that's downloadable. So if you're watching this on YouTube, please subscribe to our YouTube channel and also share this with people you know. So spread the word. This is the feedback I get is this is great content, and it's stuff that a lot of lawyers aren't doing. So we're here to help educate the public. We have offices throughout California, in Northern and Southern California. And we have a full complement of lawyers to help out our clients all over the state. And we've got a lot more people than we used to have. So I'm Jim Cunningham. I'm a CEO and partner at Cunningham Legal. I have 30 years experience. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker, securities insurance licensed, and a pilot. And as I mentioned, a father of 3 adult children. So I've been through this. And as we go through the materials, I'll comment a little bit on my own family experience. So I've sort of lived the dream. So let's talk about the legal aspects every family should consider with college-age kids. So just on a very high level, at the age of 18 in the state of California, you are a legal adult. So the decisions as an adult have a much farther reaching consequences than when you're 17 or younger, right? So there's no juvenile court. That's gone. You're just in the regular adult court. And this is really important. Parents are no longer legally responsible for their children once they turn 18. So, there's an element of legal responsibility prior to age 18, and also a certain amount of authority you have over your minor children. So children who are under 18, but once they reach 18, they are an adult. So what can you do at 18? An adult can make a legally binding contract. A minor can't, right? Maybe it's voidable. Maybe they can make a contract, but they can back out of it. But now, once you turn 18, that signature can be enforced under law. you got to follow through with what you agree to do. And this, I think, is kind of a hard thing for a younger adult to understand. It's like, well, I really wanted to buy that fancy sports car when I turned 18 on my 18th birthday. But, after a couple of days, I realized it was kind of a foolish mistake and I shouldn't have done that. That is called a cooling off period. So many contracts have a cooling off period. You can sign, but within 3 days, you can say, I don't think so. But motor vehicle sales in the state of California are not covered by a cooling off. So if you get really excited about getting that car you've always dreamed about, or that motorcycle, or whatever it might be, then that cannot be unwound. So just very important to consider. Also, we had a personal thing that happened in our family with my wife's nephew, her brother passed away, but before he passed away, their 18-year-old son wanted a motorcycle. And the dad said, I'm not signing that. You're going to kill yourself. The mother signed for it, and then he killed himself that day. So this is a big tragedy in our family. And it's just one of those things where, these kids, once they become 18, really can hurt themselves. And there's really not a whole lot you can do about it, frankly, as a parent. So very, very important. What are the legally binding contracts? One of them is military service. So, kids can decide, hey, I know I'm in Army ROTC and I'm going to enlist in the Army because I don't want to deal with college and I want to jump right into the military. Well, if you're a parent and that happens to you, there's not a lot you can do about that, right? Because once they're 18, they're 18. Medical treatment. So another thing is, they're responsible for their own medical treatment and they make medical decisions. Buying a car, we mentioned that. Marriage. Once they turn 18, they can freely get married to whomever they choose. Buying and selling real property, stocks, lawsuits, and wills. We'll talk about that. So they can sue and be sued, as well as own assets in their own name and make a will. So very important to understand the aspects of the judicial system, the legal system. The juvenile court system is a different system than the adult system. And a lot of people don't realize this. So you might get treated differently as a minor once you're an adult, of significantly more, more draconian, right? It's less rehabilitative. It's less, well, we'll give this person some slack. A lot of those juvenile records aren't available as an adult, but once you're an adult, they are. And from age 18 to 20, 19% of crimes are drug-related, 12% are property crimes, 10% are assault, and 9% are larceny or theft. So important to understand, and certainly what's legal in California may not be legal in other states, right? So if your child is raised in California, born in California, and goes to Florida, there are a lot of things that are illegal in Florida that are perfectly legal in California. So again, it depends on where you're going. So selective service is very important. Almost all men ages 18 to 25 are required to register for selective service, and it has to be done so within 30 days of turning 18. And if you're immigrating, if you're coming to the United States for school, for example, it's within 30 days of turning 18, and you must register to qualify for certain federal and state financial aid, as well as certain job training. And you register at sss.gov. And you can have 5 years in prison or $250,000 fine. So if you've got a son who's reached age 18, selective service, that's just something you have to do. Firearms is a little tricky because firearms are regulated federally. They're also regulated state by state. In California, there are certain firearms that are prohibited to possess in California, broadly speaking, that are not you're not prohibited to possess them in other states. So persons can be prohibited in California. You can be a prohibited person. So there's a long list. It's about 4 pages long from the California Department of Justice, all the people who cannot possess a firearm. Possessing a firearm is holding it in your hands, in your car, in your house. That constitutes possession of a firearm. So it's very, very broad. So you cannot buy a firearm unless you're 21. There are some exceptions. And to that, if you're 18 and over with a valid unexpired hunting license issued by the Department of Fish and Wildlife and a certificate of competency for hunting safety. So many of our clients do like to hunt, and many people hunt for sustenance in more rural areas. So there's a carve out there, but you can't You can't buy a firearm, generally speaking, until you're 21, unless you fall within this exemption. So we're going to touch briefly on 529 plans. Then we're going to get to advanced healthcare directives, durable powers of attorney, and wills. So with a 529 is a college savings plan. That's our education savings plan. That's what it started out as many years ago. And these assets are put into these accounts and they are invested and they grow free of federal and state, it says state taxes, but free of federal and state taxes. And there are different ways of holding a 529, which we're going to cover. You can designate a successor owner, but not a successor beneficiary. That's important. So if you have an education savings plan and maybe your kid doesn't use it, you can designate a successor owner. But in terms of picking, some random person, you can't do that. So the different types are individual accounts. That's where an individual owns it. A trust would be in someone's living trust. An UTMA or UGMA account, UGMA or UTMA, Uniform Gifts to Minors Acts or Uniform Transfers to Minors Acts. It's a different way where actually the minor's the owner of that. A joint tenancy account, maybe a married couple doesn't have it in their trust, but they own this 529, or a minor-owned account. And so an individual account on the 529 plan is one adult who owns and controls the qualified education expenses of a designated beneficiary. Joint tenancy is more than one adult, and a trust is when it's in your trust account. And UTMA and UGMA is just a different way of holding it, where the minors has it in their name. It's most people will have this in their own name or have it in their living trust, and we do cover this in other webinars as well. So let's look at an example, the Jones family, and just think about the Jones. Harold and Wanda Jones have a son, Sam, and he's been admitted to the University of California at Santa Cruz, where I went. And Sam turns 18 this spring, right? So Harold and Wanda make sure they can help Sam in a medical emergency. They also want Sam back here. So they want to help Sam in a medical emergency, and they want to make sure that they have access to Sam's academic records, because Harold and Wanda are paying for their son, Sam. They're paying for Sam's education. So how do you do this? How do you make sure that if Sam has a medical emergency, that the parents can be the ones making decisions? Because if there's nobody there, what do you do? And we're going to talk about that. And also in terms of having access to grades. So very important. Here's a little bit of a hack. This is the emergency contact on an iPhone. You can add emergency contacts. So you go to your health app. This would be on Sam's phone. So they go to the health app and tap your profile picture, tap medical ID, tap the edit, then scroll to emergency contacts, and then add an emergency contact. By the way, this is something that you should be doing anyway if you have an iPhone. These are people who are notified if there's an emergency SOS, and if and the medical providers have access to this. So your emergency contact information. So very important to make sure that that's in there, because you know what? Your kids, if they have an iPhone, it's always going to be on them, right? They're never leaving that thing anywhere. So if you're watching this on YouTube, please subscribe to our YouTube channel. And let's talk about the Uniform Statutory Form Durable Power of Attorney, and we'll use this within the context of the Jones family. So the Uniform Statutory Form Power of Attorney gives one person, who's called an agent, the legal authority to make decisions for another person, which would be the principal. So in our case, Harold and Wanda would be the agent that Sam designates. So Sam is the principal, meaning Sam is the one who creates the Uniform Statutory Form Power of Attorney and names Harold and Wanda, his parents, as the agents to step into Sam's shoes and do everything property-wise that Sam could otherwise do. So this is very important. Paying bills, managing bank accounts, selling or buying property, and you can even add in there accessing the records, the school records. So to find out, hey, how's Sam doing? Sam, as the kid, retains the ability to do whatever Sam wants to do. And if Sam is unable to do it or unavailable, maybe Sam goes abroad for a year and the parents need to deal with stuff, need to deal with Sam's affairs. Harold and Wanda, the parents of Sam, do that using the durable power of attorney. So if Sam's unable or unwilling to do stuff for Sam, the parents can step in and do it. The parents can also step in and check in on his grades. That needs to be laid out in the durable power of attorney. So that should be included, the power to access the registrar's records and get Sam's grades. You know, at UC Santa Cruz, when I went there used to be no grades. It was written evaluations. I guess now there are grades. So a little bit different than it used to be. So let's go back to our example. Sam gets in a bad bike accident and is unconscious and rushed to the hospital. This is like every parent's worst nightmare, right? Something happens to Sam. He doesn't die, but he's really out of it. It's a really bad bike accident. Once Harold and Wanda are notified, they can use Sam's advanced healthcare directive, which we'll talk about. So this is something that'll be a little bit later in our example. That's to use for medical decisions. But Harold and Wanda can use the durable power of attorney for property to handle issues related to college enrollment. You know, if Sam needs to take a break from college, if he cannot finish that quarter at UC Santa Cruz, then Harold and Wanda can talk to the university and deal with things. So again, you don't want this to happen to your kid, but you know what? Stuff can happen. Hopefully it won't happen, but if it does, this certainly relieves a lot of burden, a lot of this sort of administrative burden on Harold and Wanda, so they can focus on Sam's recovery. If someone was at fault for the accident, maybe Sam was hit by a car, they can initiate legal action against the person who was responsible for Sam's accident using the durable power of attorney, as well as communicate with Sam's health insurance provider. So, right, when you go to the hospital, you're going to have to be dealing with a lot of things. And the durable power of attorney for property allows the parents, Harold and Wanda, to step into the shoes of Sam and act as if they are Sam. So that's the concept of agency authority. So Sam grants this agency authority to his parents, and this can be significantly more cumbersome without these estate planning documents. So if you go click the link that I don't know if we're going to be putting it in the notes now, but it certainly will be on our YouTube page. If you click the link on the YouTube page, it pulls up this uniform statutory form power of attorney. And what you do is you put Sam Jones in there, and then Harold and Wanda Jones. And this is all made up. You're not going to put these names in there. You'll put the name of the kid in there, as well as the name of the parents, and then the street address. And what a lot of people do is they check N. N is in Nancy or November. All the powers listed above. So all the powers, and then you may want to have some optional instructions on their additional powers, which might be, speak about grades or talk to the registrar or whatever it might be. And maybe we can give some examples of language in the notes when this goes up on YouTube. So this is how it's filled out. It is then notarized, acknowledged before a notary public. It's kind of important here. If you name more than one person, so if you name parents here, it says on the slide here, it says exercise of power of attorney where more than one agent is designated. It's important to say whether they have to act jointly or independently. Most people are going to want independently, which means either of them can act. So who needs a copy? Well, you need to keep this thing safe. It's an original legal document, and it should be kept in a safe and known location. If you have a lawyer, your lawyer should also have a copy. It's very important. Sometimes the lawyer is contacted. If the parents rush to the hospital, they say, we don't have these documents. They call the lawyer's office, and we send that over to whoever needs it. And everyone who signs this should have a copy. So this means Sam and each of the parents should have a copy. And the people who might need a copy are the bank, the doctor's office, the school, the recorder's office, if there's any real estate involved. So typically children don't have real estate, but sometimes they do, right? Sometimes they have an inheritance or some partial interest. So let's talk about the Advanced Healthcare Directive. The Advanced Healthcare Directive is where you express your healthcare preferences if you're unable to communicate them yourself. So what this is fundamentally very similar to a durable power of attorney. This is where you are giving decision-making authority to another person when you're unable to make those decisions for yourself. So a little bit different than a durable power of attorney, because Sam could be studying abroad and the parents are here and the parents need to deal with something. Well, Sam could be taking those actions, but he might need to notarize something. And if you're in a foreign country, it's not going to work. Advanced Healthcare Directive, if you think about it, Sam, the human, is in the hospital. And if Sam can articulate Sam's healthcare wishes, great. You don't need an Advanced Healthcare Directive. So this typically only comes in when Sam is unable to articulate Sam's healthcare decision-making authority. That's typically what you see. So it appoints somebody to make healthcare decisions. This is different than a medical order. So there's a POLST, a physician's order regarding life-sustaining treatment. It's the pink kind of card-like thing that people fill out and put on their front door at the assisted living facility, right? The POLST, POLST, the physician's order regarding life-sustaining treatment. That tells the EMTs that show up, don't give me mouth-to-mouth resuscitation. Don't try to resuscitate my heart. I'm terminally ill. Let me go. Totally different than SAM in college, right? So the Advanced Healthcare Directive and POLST, something totally different. The POLST is a medical order, a medical directive. Advanced Healthcare Directive, SAM is giving to his parents the ability to make healthcare decisions for SAM. You can talk about wishes regarding medical treatment, organ donation. You can designate a primary care physician. And this helps the parents make medical decisions for Sam, because once Sam turns 18, really Sam's the only one who can make that medical decision-making authority. Now, California does have a recently enacted surrogacy statute. So if you go to the hospital and Sam says, I'm out of it, they go, who do you want to make decisions for? I want my parents to make decisions for me. That's typically good enough for the hospital. But realistically, this is something you're going to want to have in order to access Sam's medical records. So that's another wrinkle on that we'll talk about. So this is a parent tip from a recent graduate. When you send your child off to college, schedule them an appointment with their primary care physician, with the hospital, with the nearest emergency room. So having a primary care physician is very important for health reasons, so they can easily get prescriptions if they need it or know where to go if they get sick. But having that primary care physician, if your kid goes to school at Santa Cruz and you guys are living in LA, Sam probably should have a primary care physician that's in Santa Cruz, at least nominally a primary care physician. That physician's in the healthcare directive and it's on file. So in case they're ever brought into the hospital, it's gonna help with things. Certainly if you have a child that has certain medical conditions or specialists or whatever it is, you would want to talk to your medical doctor. But if you don't have something like that, one little hack is getting a primary care. So this might mean switching your primary care, which a lot of times happens from you're with the pediatrician until a certain age, and then you reach and you're not going to the pediatrician anymore. So they're going to need to get a primary care physician anyway. Probably a good idea to get one where, like in Sam's case, somewhere in Santa Cruz. So Sam gets in a bad bike accident, is brought into the hospital. Using the Advanced Healthcare Directive, Harold and Wanda can make immediate medical decisions, have access to medical records, monitor treatment, coordinate the ongoing care, authorize necessary procedures, and decide on long-term care options for recovery. So in the notes, there is a link to the California Advanced Healthcare Directive. This is a product of California statute, and it's pretty straightforward on filling out. And you fill out the name, who you want your agent to be. So Sam designates Harold and Wanda, and you can limit the agent's authority, or you can just say, look, I give them blanket authority. And you can talk about post-death authority. Typically, we're not doing this with children who are going to college. Typically, it's something we talk about with older clients. And then this is kind of important, the choice not to prolong life or prolong life. And, many people say, look, if I'm a goner, pull the plug. That's really what this 2.1A and B are about. Some people say, if I'm a goner, keep me hanging in there. So again, this is not a medical order. This gives authority. In this case, Sam is giving authority to Sam's parents to withhold or withdraw life support, right? Or not, right? So I guess if the parents say, look, we want to give it a little bit more time, they would have that authority under the Advanced Healthcare Directive. And there are some other things that, as you read this, do you want organ transplant? A lot of people have the dot on their driver's license, which is another way of accomplishing the same result. And then, of course, you have your primary care physician. So in this case, we'd recommend that Sam get a you should always have a primary care physician, get a primary care physician in Santa Cruz, because Sam's at UC Santa Cruz. And then you would complete that primary care, put that primary care physician information in the Advanced Healthcare Directive so that it's available if needed. And then you can sign it and date it. It can be witnessed. It can be acknowledged before a notary public. And this part 6 about special witness, this is only applies if a person is a resident in a skilled nursing facility. So typically not going to be someone who's going to college at UC Santa Cruz. So you can kind of ignore part 6. for the purposes of this advanced healthcare directive. And we typically do have these notarized. So you can have them witnessed or notarized, but we typically, you can kind of mess up the witness signature. Frankly, it's better to have a notary do it. So provide copies of the provide copies to healthcare providers. This would be the primary care and any specialist and the hospital that your child might be admitted to, as well as the campus health services, parents, child lawyers, and store a digital copy of the advanced healthcare directive. Very important to have that. That's something that we have on file with our clients. And many times they, if they don't have it, they're going to be asking for it. So HIPAA authorization is a slightly different, it's a more nuanced document, and it can be incorporated into the Advanced Healthcare Directive. It can be a standalone document. So HIPAA is federal medical privacy. California has a state enacted version of it. A HIPAA authorization allows people to access medical records. So in this case, Sam is perfectly fine, not incapacitated. We are not talking about accessing medical, or we're not talking about medical decision-making. We're talking about the parents accessing Sam's health records. Now, Sam may not want to share those with mom and dad. So you would need to write these documents accordingly. And if this is something we can help you out with, right? If you don't have a lawyer, certainly reach out to us. But this is a slightly different document than an Advanced Healthcare Directive. Advanced Healthcare Directive says Sam's unable to make medical decisions. Okay. So we're going to make those and have access to his medical records. HIPAA authorization says that a person has access to your records anytime, right? So, most older people, most of our clients are adults, kind of middle to late adulthood. This is something that most people should have. Certainly if you're married, you would want your spouse to access your medical records. And, but that's the difference between the HIPAA authorization and the Advanced Healthcare Directive. So Sam develops symptoms of a complex and unidentified illness while at college, a rash, vision loss, hearing loss, resulting in hospitalization. With a HIPAA authorization, Harold and Wanda can access his full medical history and discover a past case of chickenpox when he was a child, which combined with current symptoms and specialist diagnose, they treat him for shingles, which does not happen often in a young person, but and this is why it's important to have your child's medical records with your local general practitioner. So good source of data here. And this is, this is in the link in the YouTube video that will be online here, or is online if you're watching it online. The HIPAA authorization for a friend or family member, and it's pretty straightforward. I direct my medical providers to disclose my protected medical information to the following people. And you can check all the things that you want disclosed or not. And, pretty straightforward. So this should go to your healthcare provider, the primary care physician, any specialist, the hospital where your child's admitted, campus health services, parents, child lawyer, and store a digital copy so it's accessible online. So California Statutory Form Will. What is the California Uniform Statutory Form Will? This is a great Q&A. We got some Q&A. We'll be pulling up doing our questions here in a couple of minutes. California Statutory Form Will is a standardized legal document. So this is very important. This is not an attorney drafted document. And I will warn you, if you think estate planning is confusing enough, this is a very confusing document. It's actually part of the California Probate Code, and it's provided by the state of California. So the legislature said, hey, let's do this thing where we can give more access to justice, which is great, right? That's why we're doing this. So many people, they just can't afford a lawyer, but this is important stuff for them. So you can use a California statutory form will. So this allows one individual, so there are no joint wills in California. This allows one individual to state how that individual wants their property distributed after death. This is not when you're incapacitated. It's not joint will. This is just me. When I die, this is the person who gets my stuff, or these are the people who get my stuff. It appoints an executor, right? Who's responsible for carrying out the terms of the will, as well as 2 witnesses are required. So what can a will do for you? I think The last figure I heard was 70% of people die without a will. Now, a lot of people don't have much, so it may not be that big of a deal, but a will, you can designate who gets your assets at your death. If you do not designate who gets your assets at your death, then state law controls. Now, it may be the state law of your residence. It is possible that if you own real estate in another state, that state's laws may control who gets the real estate. So it's something where if you have anything, really, if you have property, you should really consider doing a will. So does a will avoid probate? No, the court determines if your will is valid. So a will is like a list of instructions to the probate court about how you'd like your stuff distributed. Probate is from Latin probare, to prove, meaning the court goes through this proving up process to determine, is this a valid last will or not? So it does require a probate process. And the will is based on California law. Don't use it if you're not a California resident. So this is just for Californians. Should you not use a statutory will? Yeah, I mean, probate avoidance. If you use a will, you're going to probate. It is not a living trust. There's no living trust form. If your assets are really over $100,000 or so, or under 100,000, yeah, you can do a will. But once you get over 100,000, you really should be looking at an attorney drafted estate plan, which is probably going to be a living trust centered estate plan. No, you can't cross anything out on there. You can only fill in the blanks. So again, if this is confusing, talk to a lawyer. You could certainly reach out to us if you needed a will drafted. So a guardian, if you have a child under the age of 18, you should designate a guardian of their person to raise them. And then there's a guardian of an estate. So the guardian of the person, so if you have minor children and that are under the age of 18 and you're doing a will, you have the ability to designate who cares for your children until they reach age 18. And that would be a guardian of the person, or that would be a guardian of the person. The guardian of the estate is if they inherit money, that could be a separate person. So a guardianship is a whole separate proceeding that you go through in probate court, actually. So separate case number, separate proceeding. So you pass away with minor children and they inherit money. If they're under 18, they're going to end up with some type of a court proceeding if there is no surviving parent, if there's no living parent. So what's a custodian? A custodian is someone you can designate to manage assets for someone under the age of 25. So a custodian goes up to age 25, guardian goes up to age 18. And a bond is basically executors in California are required to post a bond unless it's waived or the court, unless the will waives the bond or the court somehow, there's some other procedures you can do. But what a bond is basically, you have to have good credit as the executor. It's kind of where I'm the bottom line on this. If you don't have good credit, you're not reliable. If you have good credit, then you post a bond. So if you have to post a bond of $100,000, you go to a bonding company and that might cost $500 or $1,000. I don't know. So the bonding company says, this person's paying us $1,000. And if they steal the $100,000 that's in the estate, the bonding company gives the $100,000 to the court. You still owe that $100,000 if you stole it, and the bonding company's coming after you. Okay, so this is not insurance, but the way a bond works is they want to make sure you're just not going to run off with the money, and so this bond or surety company covers that if you run off with the money. That's what a bond is. So Sam is involved in a biking accident, leads to severe injuries. Despite the medical team's best efforts, Sam never recovers and passes away due to complications from the accident. His half-sister Darla claimed that Sam wanted everything to go to her and disputes the distribution. Well, because Sam had a California statutory form will in place, the court was able to confirm that his assets were to be distributed equally to Harold and Wanda, ensuring his wishes were honored and providing a clear path for handling his estate during a difficult time. Still requires probate, but it does go to Harold and Wanda. So here's an example of the statutory form power of attorney. And you fill in your name and read this very, very carefully, right? So there's some other choices. There are choices 1, 2, 3, and 4. And in this case, we would put here that choice D. So Sam would put Harold and Wanda on choice D, right? Choice 4. So option 4. And you go and you fill the blanks. There's a specific gift of an automobile. There's some other cash gifts that are optional. And then, see, this is why it's confusing. Even I'm reading this and I'm confused. This is balance of my estate. So 5, if you're looking at this, so let's go back. This is really annoying, right? I'm looking at this California. It even confuses me. So we don't use these. I'm doing this because people have used them in the past, and this is basically a free way of writing a will. But it says specific gift of personal residence, paragraph 2. So you have to read this really closely. Specific gift of personal residence. Well, Sam doesn't have a personal residence, so leave that blank. Specific gift of automobile. Sam doesn't have a car, right? Specific gifts of cash. Sam's got student loans or whatever he's got. He's got no cash. So then we go down to 5, balance of my estate. Well, what are we talking about here? Sam might have a personal injury recovery, right? Now, typically your pain and suffering dies with you in California, but there may be other things that are in his estate. Who knows? I mean, there could be something. This way it goes to Harold and Wanda Jones. So you would check 5, balance of my estate, and then Sam has no children, so there's no guardian. And then the executor is first Harold, then Wanda, and then Sam signs a waiver of bond in item 9, and then at the very end signs the will. Sam does sign his own will, and then we have some witnesses here who are not the parents sign as witnesses. So that's a California statutory form will. I would say the parents should have a copy. Sam needs to keep a copy. The lawyer should have a copy. You can store a digital copy. And in California, there's no requirement to file a will with a court while Sam's living, so this stays private. But when Sam does pass away, then there's a requirement to lodge this will with a court. So how do you get all these forms? Well, you can do it yourself or not. Now, each county has a different form. So each advanced healthcare directive might have a slightly different iteration. A lot of times the county court systems will post these online. I know LA County has a specific form. We can do customized attorney drafted documents via Zoom. So if your kid's off at college, we can have them meeting with your child and go through all the things that we kind of talked about here and get these written up. These would be attorney drafted, not the uniform statutory form wills. They're a little bit limiting. And this bundle would include the last will and testament, the durable power of attorney, the advanced healthcare directive, the HIPAA authorization, and electronic storage of all those documents. So if you need them, we can get them to the right people. And fees are quoted on an individual basis. So if you say, you know what, Jim, thanks for sharing all this information about the freebie stuff, but you know what, I just want to get it done, and I want to get it done right. If you have a larger estate, maybe your child is a beneficiary of a trust, and you might want to exercise a power of appointment. You might want to do something that's a little more complicated. That definitely does require attorney involvement. So my second edition of my book, Savvy Estate Planning, is out. We cover a lot of what we talked about today in Savvy Estate Planning, and you can get that from our website. Just type in Savvy Estate Planning, Cunningham Legal. And if you're watching us on YouTube, please subscribe to our YouTube channel. And if you really enjoy our webinars or you're a client, please review us on Google. Those reviews on Google really help us do a better job for our clients. And we'd really appreciate a favorable review. Next up is asset protection using LLCs, partnerships, and corporations the right way. This is May 9th. So asset protection, very important to a lot of people. Maybe protecting your assets, maybe protecting an inheritance, right? If you're going to leave an inheritance, so if Harold and Wanda are leaving an inheritance to Sam, they don't want it going to Sam's future ex-spouse. So very important topic. Now we'll open it up for questions. If you're watching this on YouTube, you can go ahead and just keep watching because another video will magically roll up after this one. And thanks for joining us.